Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. Welcome to our Thursday community conference. Once we hold it on this bridge, which you called in, and once on LinkedIn audio. Okay. And the calls are announced on our social media. Now, this is before we get started, there's about 4 more minutes left. So I'm just going to address one question from Texas before we start the call. Let's see. Texas, go ahead. I can hear you. Texas.
Hi, Rajiv.
Hello.
Hi, Rajiv. Can you hear me?
I can hear you. Yes, please. Go ahead.
Yes. My question is regarding my options in the U.S.
Mhm.
So a little bit context. I am on a H1B visa, and I was impacted by the layoff
Uh-huh.
in the April of 2023.
Mhm.
And my grace period of H1B ended in November of 2023.
All right.
During my 60th day, I applied for the change of status to
Mhm.
B1, B2.
Mhm.
And in February of first week, I heard back that my B1, B2 change of status has been approved.
Okay.
And the B2 change of status validity ends in the first week of May.
Okay.
Considering I'm still in the hunt for a job,
Mhm.
for whatever reason, say I don't end up finding a job, by end of April, what are my options
Well,
to continue my job search in the U.S.?
okay. The options is a very wide question. That's not something I can answer.
Mhm.
But one obvious solution is to apply for an extension of your B2 again. Okay. So using the
Okay.
same paperwork, apply before the allowed time ends. Make sure that your application for renewal is received by the government before your approved time ends. That is the most obvious solution. Okay.
Okay. So I have a follow-up question. How many times can we file for this extension?
Well, I
Let's say I do
think
file it for this
I
extension
I
again.
think that is largely an academic question because nobody can predict the outcome of a third application. But I can easily see first and second applications being allowed. Okay.
Okay. And if the time permits, I have another question, if you don't mind.
I have hold on,
Yeah.
hold on. I have about a minute and a half. If you can cover in that, I'll be happy to answer it. So go for it.
Absolutely. So if I do decide to move back to my home country for whatever reason, at a high level, what are some immigration related factors that I'd have to take care before I move back?
There's nothing you can do before you leave. The only good part of this exercise is that since you held an H1B, worked on an H1B, you will not be subject to the lottery for the next 6 years. Okay.
Sounds good.
Good
Okay.
luck. Ma'am, I've got to go.
And
I've got to go.
thank you.
Good luck.
Yeah, no worries. Thank you so much.
Bye-bye.
Thank you.
Okay, folks, we're going to start our conference. Just want to lay out a couple of things for you. I have a lot of questions that I think are frequently asked questions today. So unless your questions pertain to those questions that I've marked or that have been posted already, we probably will not have time for new questions. Okay. I have pretty much everything charted out already. So if you wanted new questions, they probably will have to wait till the next call. Okay. Now I'll go over the frequently asked questions first. I will answer them. And if you have any follow-ups, no new questions. If you have any follow-ups on those frequently asked questions, I'll call every time I finish my conversation. I'll call upon you. Feel free to ask your follow-up questions. And after that, I will start on the other posted questions, which I don't consider to be frequently asked. Okay. So question, follow-ups, question, follow-ups. That's how we'll work. But we will not have time today for new questions. Okay. I will also lock the conference once I feel that we have enough people in the call and we cannot handle anymore. So we'll just lock the conference at that time. My first frequently asked question is, there is a blacklisted employer and people are getting turned back because of that blacklisted employer. What should we do? What is the impact on non-immigrant visas and maybe even green cards? So these kind of problems with a blacklisted employer in your background, we are just using the term blacklisted, let's say under investigation or under suspicion. What is the impact on F1, H1B, L1, H4, F2, any of these visas, right? Like I said, if there is a suspicious employer in your background, it can have a long-lasting impact. Okay, so this is the question that Shraddha asked me. She said, my friend's F1 was recently revoked, forced to return to India because the first employer had been placed on a blacklist. He has applied for an OPD extension, then he gets an updated EAD, but how would this impact the process of getting a new EAD? He's working with the firm on a contract now, and they want to sponsor him for his H1B. His old EAD expired on 9th of January. He was traveling from India to the States on 4th. He went back. Is there any way he can reinstate or have his company sponsor H1B, etc.? Now, folks, I'm going to lock the conference because we have enough people already. So 1 second.
The conference is now locked.
Okay, I'll just remind everyone that I don't know if we'll have time for new questions, but certainly we'll have time for follow-up questions of what we are discussing. So here, they want to know, can we apply for an H1B, etc., etc. In a case like this, addressing your question specifically, and then I'll answer the general impact of these kind of situations. So for your question specifically, whenever you are turned back at the airport or port of entry, it can be done one of the two ways. One way is the government will say, you can withdraw your application for admission and leave. In other words, voluntarily choose not to enter the US. What is the advantage of that? The advantage is, in those kind of cases, you then are not subject to 5-year bar from entering the US. Second way they can do it is they can take your statement and they can say, okay, here is your refusal of admission. Now you cannot come back on any visa for 5 years. Okay. So first of all, it depends upon how they turned you away. If they turned you away with a 5-year bar, you still might have a waiver. But if they turned you away based upon your withdrawal of request for admission, then there is no problem on trying to look for other ways to come to the US. Okay. The biggest problem that I have in these cases is, often when you have participated in the activities of an employer whose activities were fraudulent or considered to be misrepresentation, the government will consider you to be barred under fraud grounds. That is a permanent bar from entering the US. You can never come back. It's very difficult to get a waiver based upon when you have a permanent bar based upon fraud laid upon you. So that's a very difficult situation. Okay. What can you do to avoid it? Are there any people who arguably have a way out of this situation? So one of the employers who's very much in the news, and even universities are sending letters to students saying that you were involved with this employer as a part of your OPT. So talk to an immigration lawyer because you have a problem. Okay. So when you have an employer like that, my first question, when I do a consultation for something like this, my first question is, how deeply were you involved? So what does that mean? Did you know that you were committing fraud? 2, did you believe this company was genuine? They were going to give you a job on OPT or STEM OPT. 3, did you pay them any money? 4, did you actually get any training? Did you actually work? Okay. So if the more of these questions that you answer in the negative, other than the fee question, if it is answered in the positive, chances are you'll be held to fraud standard. And how long was your association? If you were involved with them for 1 year as opposed to 1 day, there's a huge difference. So the moment you found out this employer is probably fraudulent, you left, you're probably okay. Can you file lawsuits, etc.? So far, I am not aware of any lawsuits that have worked in these situations. But if the extent of your involvement is marginal, you should be okay. All right. So now, anybody has any follow-up question on what I just talked about, press *5. No new questions, please. Any follow-up question on what I just discussed, press *5 on your phone. Okay. Here is one from area code 551. Let me find you. Area code 551. That doesn't make any sense. Oh. Well, here it says 551, but I see a hand up from 202 area code. Not sure what's going on. All right, let me try unmuting 551. 551, I can hear you. Please go ahead.
Hello, sir. Thank you.
Sure.
So my follow-up question is regarding traveling to other countries. I understand US has a bar place, but if I'm traveling elsewhere in future, would this affect visa for tourists, etc., like that?
So that depends upon the way the country views visas to US and what their local laws are. So if there are 200 countries, there might be several varieties of laws. Okay. What I advised to the person I talked to today who was stuck in this situation, what happened was they got an email from the school saying that you have this company in your background. We want you to reach out and talk to an immigration lawyer. Okay. So when he called me, I found out that he had been with them 6 months. He had also paid them and he never received a day of actual training from them. This is what I told him. I said, listen, there's a very high likelihood if the government wants to make an issue of it, they are going to hold you on fraud. If they hold you on fraud, you will not be able to get your green card or convert your H1, to convert your visa to any other kind of visa. And you'll have problems maybe even in third countries. Okay. I know that Canada has something that, I practice only in USA, but I believe Canada has some negative implications if you have a fraud-like situation in USA. So I said, before you get into trouble, why don't you just apply for immigration to a third country like Canada? If this situation doesn't get set up as a black mark against you, you can do a Freedom of Information Act request, make sure there's no negative information about you, then try for an H1B visa later. Okay. So that would be one way to handle it. What is the difference between your question and this guy's situation? In your hypothetical, you're already in trouble, but here he might be ahead of the trouble.
Okay. Got it, sir. Thank you.
Good luck. Any other questions? Press *5. Any follow-ups? Press *5 on your phone. Okay. All right, this is done. Let's go on to the, that was New Jersey. Yeah, that's done. Let me go on to the next frequently asked question. Like I told you, I had a whole bunch of them today. So this is about H1B Visa and Entrepreneurship, launching a business with US citizen brother, shareholding, green card, etc. So first, let me answer these questions specifically. Then I will tell you generically what's going on. So I'm currently on H1B visa. I'm planning to start a business with my brother who's a US citizen. Until the business is operational and generating revenue, can I just be a partner with the company without doing any work? So you cannot have an H1B as a partner in the sense that you're not doing any work, you're just a partner. No such thing. H1B requires the payment of the base salary. Okay. Can I have more than 50% share in that company? The answer is, under the current regulations, I think it's a bad idea because it casts grave doubt on whether this is an employer-employee relationship. Okay. But by the way, there are regulations pending which would make it easier, but those regulations have not yet been finalized. In the future, if I want to file for concurrent or full-time H1B through the new company, is it difficult to get it approved? If my brother and I are partners, no. If you are a minority partner, your brother is the majority partner, and the job is in your own field, this should be possible, a concurrent as well as a full-time H1B. But can you file a green card through this category, through this company? The answer is no. Because when you have ownership in a company, filing a green card from that company through that company is extremely difficult. Okay, not the EB2, EB3 kinds. EB1A, of course, does not require a job. A national interest waiver doesn't require a job. Okay, next question. Okay, I covered that. Does the company need to meet any specific conditions before sponsoring for H1B? No. For H1B, if it's your company, look at the law. It only says you have to be a US employer, which means you have a tax ID in the United States. In addition to that, if they send people, USCIS sends people to audit you or look over your operation, it's nice to have a commercial operation. It certainly is not required. Do you have to be E-verified? Only if you are going to provide jobs to people on STEM OPD. Do I have to have at least few citizens before hiring non-citizens? No. There is no such requirement. Can we file green cards for employees? Well, if your company is making enough money to support salaries, and it's obvious from their tax returns that you're making enough money, you can apply for green cards for your employees. For H1B, we are concerned about the availability of the job. Is there a project here? For green cards, we are concerned both with the job as well as the ability to pay wages. That's how it works. Okay. So other than that, I don't think I have a whole lot to say. You can always be a passive owner in a company where you have no activity at all that you do for the company. That can work. Yeah, rest of it looks okay. So I don't have anything else to add. *5, anyone has any question, press *5. Any follow-ups on what I just talked about? Okay. So next question is about, this I get asked a lot. National Interest Waiver Standards. AI list of critical and emerging technologies focus. So I have a master's degree in STEM, AI focus. I have the intention to create high impact in it. Will that be enough for NIW? Well, maybe. Do I need more qualifications? Not really. Okay, first of all, the impact of working with emerging and critical technologies is not yet clear. Government may give us new regulations, new policies by the end of April. Right now, it is not clear. We are arguing, where possible, that obviously these technologies create a presumption that they are in the national interest. But then the second question is, fine, even if the technology is in the national interest, what is the impact of your work? So if I say I am working in creating responsible AI or transparency in AI for one employer, government will say, well, then you're helping one employer. How are you helping the United States? So national or non-local impact of your work has to be proven. Be mindful of that. I will lose an NIW where I'm not able to prove that your work has impact beyond the four corners or four walls of a company. Okay, that's how it works. Press *5 if you have a follow-up question. Okay, area code 858. Where are you? California. Okay, California, I can hear you. Go ahead, please.
Yeah. Good afternoon, sir. Can you hear me?
I can hear you just fine. Good afternoon.
Yeah, thank you. So a quick follow-up question on NIW based upon your blog for India-born citizens, the two advantages about mobility and extension beyond 6 years
Yes.
for H1B employees. So does the 60-day period, grace period, still apply to people who have approved NIW once if they are laid off on H1B?
Yes, it does.
Okay. And if NIW is filed by employee, then do these benefits still hold of NIW?
That's an excellent question. I'm glad you reminded me of that. So when I draft an NIW, I try to keep it as open as possible and still win the case. What does that mean? So let's say that you are working in AI, okay? And within AI, you are working on one particular software. Let's say it's a cybersecurity software that looks for certain patterns of activity. It has deep learning. It will recognize patterns, teach itself, it does reinforcement learning, all kinds of fancy stuff. And you are working for the employer called XYZ company, okay? If I hook you up to that project too heavily, that you are going to work on XYZ company's project, what if you leave and go to ABC company? Now you are not working on that project based upon which you got your NIW. If on the other hand, instead of hooking you up on the project, I focus on the fact that you're working in these technologies, all of a sudden the door is open as long as you're working in those technologies. So, where possible, file the NIW yourself. Don't let the employer file. And where possible, make sure you leave the door open to be able to work for any employer. Make sense?
Yes, yeah, that makes sense. Okay.
Good.
Thank you very much.
You're welcome. Good luck. Okay, so...
Thank you.
You're welcome, sir. Let's see, I just... which one did I just do? Darn. Don't know. I think this is the one, 858. This one is 856. Yeah, 856. Go ahead, please.
Hi, Rajiv. Thanks for doing this. So, quick question. I'm currently on H1B, got laid off and all of that, and I'm also developing an app which gonna help like artistic community. So I was kind of wondering if that falls under national interest waiver, because I spoke with like different artistic community how to kind of outline their say ticketing system, run the show smoothly, and a lot of other features. But it impacts like artistic community across say America. So
Okay.
does that fall under
So,
NIW or how does that work? Thanks.
We can certainly argue for it because art and culture are very much a part of the national fabric. Not everything has to be life and death. Having a good life is just as important, right? So it can be argued. But the difficulty you'll have, there are two difficulties I can see. One is, how do you
Okay.
prove that there is interest in the US in your work? Okay. Are people interested in your app? Do you have companies that want to work with you? Or do you have buyers already lined up? So that would be one thing. And the second thing would be impact deep and wide enough to be called useful for national interest. So are you going to have 1 million users, 50,000 users, 500 users, something like that? Are they going to be one state, 10 states, 50 states? So those are the questions that we need to explore. But it's possible, I think, because remember, we've done many NIWs for arts and culture-based systems as well.
Okay, got it. And what would make a better case in your understanding? Like if I have, say, 50,000 users spread across, say, 5-10 states, will that be a better example? Or rather than, say, 50,000 users out of only one state or
Yeah, I
less
think,
users? Sorry, I meant like 10,000 users across 10 states versus 50,000 users in one state.
I don't think we can quite quantify it like that. But the wider and the deeper, the better. So more people over more states, the better. What would make your case better is if there's a US company that says, we really like this app and we would like to work with him on it. If there's some kind of a letter of interest, that would also be very helpful for you.
Oh, that's great, because I was formulating like a pitch deck and reaching out to other investors and whatnot. So I'm still working on that part. So just letter of interest would be enough, not like some sort of agreement that they will be investing. Okay, that's perfect.
That should be enough.
All right. Thank you so much.
Good luck. Okay, folks, let's go on to the next frequently asked question. So OPD EAD errors and typos. This is a tough one. I haven't really researched this, what the deep options are. So I'll give you off the cuff answers to questions that I kind of know the answers to. But remember, law is full of surprises. Things should be researched. So don't think that this is the definitive answer on your situation. So here what is going on is I graduated in May 2023. I'm working with an NGO and looking for a job. USCIS sent me an EAD with the wrong photo. It's a typo. I sent it back with the correct photo. They sent me another EAD with the wrong photo. In Jan 24, I also made a case to Ombudsman, but they were not able to assist me. Can I apply for a new EAD? I have passed the 60-day after graduation period. This is a tough case to answer or resolve. Or should I use the EAD that's already there? Absolutely. I would use that EAD. But there's another option. I'll talk to you about that. Or can I wait until EAD renewal and get EAD again? See, there is nothing in law that stops the running of that 60-day, 90-day period. You should have 90 days in the first year, right? 60 days in the next 2 years. So there's nothing that can stop the running of that time. So I'm going to give you one option that you may or may not know about, something called receipt rule. Receipt rule. So normally we apply for a replacement EAD if the EAD is lost or if we made a mistake on the EAD. Okay. So if you apply for a replacement EAD because of the government error, you can of course request for a waiver of the fee for the replacement EAD, but file it. And if you get the receipt, you can actually start working with that receipt. That will protect you. Okay. And then at the same time, call the USCIS customer service, tell them that you need this case expedited because it's government error. And they should expedite the case. All right. So 2 things, even though it's not your fault, apply for a replacement. You start working with that receipt so you don't have that 90-day out of work problem. And if you're in the first year of OPT, you can actually work without getting paid. So you are okay. That's not an issue as long as it's 20 hours in your own field. So those are the things that I can think of. Okay, this is very unfortunate, most regrettable. *5. If you have a follow-up question, press *5. Doesn't appear to be a follow-up. Let's go on to the next frequently asked question. How to calculate H1B grace period? Further, H4 change of status, H1B transfer delays. Could you analyze the following situation from H1B 6-year max out perspective? There is no approved perm or I-140. Employer gets laid off November 20th. They file for change of status plus EAD. Employee gets a new job, EAD is pending, H1B transfer approved. Okay. Does the grace period count towards the 6-year H1B? Yes. Because while in that 60-day grace period, you are still considered to be on H1B. It does count. When change of status is pending, does it still count towards the 6-year max out? After 60 days, it should not. That would be my calculation. So after 60 days grace period, you have something pending, but you're not on H1B anymore. Then H4 change of status, EAD and H1B transfer count towards the 6 years. So I'm not sure what that issue is. So I can summarize this situation that anytime you are on H1B or in the 60-day grace period, that's counted towards H1B. When you are on H4 or H4 pending or B1, B2 pending after the 60 days, that is not counted towards your H1. When you apply for change of status from H4 to H1, until the change of status is approved, your H1B doesn't start running. So you're not on H1 yet. So how does USCIS keep track of all this? They don't. They ask you. Of course, they do the math. Once you give them the details, they do the math as well. But it is your responsibility to claim the time. And any time you spend on H4 status is not counted towards your H1B. I think I've covered your question. Star 5, if you have a follow-up question on this. Star 5. Okay, so let's see. This is from area code 475. 475 is from Connecticut. Okay. Yeah, Connecticut, go ahead, please.
Sir, thank you for having these sessions.
Yes, ma'am.
I'm Chandrika.
Uh-huh.
I have one short question.
Go ahead.
Sir, I got laid off and my 60 days grace period is over. I have applied for B2 change of status. But what I'm wondering is, even if some employer wants to file sponsor my H1B, I mean, I'm trying to get a job meanwhile. Will I have to wait until October 1st of this year, or I can start working as soon as I get a new I-797?
Okay. You were working on H1B already, Chandrika ji, right?
Yes.
Okay.
Yes.
So if you had filed your H1B within the 60 days, you could have started working as soon as the petition was received by the USCIS. But now the 60 days are gone. You have to wait for the H1B approval before you can start working.
That's true. Yes.
Okay. Now, because you're out of the 60-day grace period, and if your B1, B2 is not yet approved, when they decide your H1B, they could approve the H1B without I-94 asking you to go get a visa stamp. So when you file your H1B, make sure you request the government to expedite the B1, B2 so that B1, B2 is decided, then H1B is decided within USA. Okay?
Okay.
So when you file the H1B, tell them not to keep the B1, B2 pending, to please expedite. Okay?
Sure.
Anything else?
And will I be...
Yeah?
Sir, will I be waiting till October 1st?
No. You can start working as soon as the H1B is approved.
Oh, okay.
Okay? You don't have to wait for October.
Yes.
One quick question. Which year were you selected for lottery?
Last year.
Year.
My
So
H1 started last.
Then you are fine. The moment your H1B is approved, you can start working. No problem. Okay? As long as it is approved with the I-94. If they say, it is approved, go get a visa stamp, then it's okay. Go get visa stamp and start working. You can go to any of the neighboring countries. Okay?
Yes.
You don't have to go to India. Good luck, ma'am.
Yes. Thank you, sir.
You're welcome. Bye-bye. Area code 858 is California. California, go ahead, please. How can I help you?
Yes, sir. Sir, connected question. If during the 60-day grace period, can I use my B1, B2 if the 60-day grace period gets expired, assuming I have an approved B1, B2 before the H1B was approved?
What do you mean, can I use my B1, B2? What do you mean by use my B1, B2?
So if the 60-day grace period has expired, so can that B1, B2 allow me to continue staying here?
Oh, yes, absolutely. If you file your B1, B2 before 60 days, you can continue staying as long as it is approved, as long as it is, pending. Unless it is denied, you will then have approval and you can continue staying. And if you need to file another extension, do it before that period expires. So having a timely filed B2 pending allows you to stay in the United States. Okay?
So I already have an approved. So it was approved before the H1B was filed and approved.
That makes no sense. So I have no idea. What you are saying is you have a visa stamp on your passport.
Yes. Yes.
That has no meaning. Okay. So you have to apply for a status.
Okay.
All right.
Okay. Thank you.
Good luck. Okay, let's go on to the next. I think there's more frequently. Oh no, they are over. Okay, let's go to the regular questions that are posted. Leaving H1B sponsor. This is question number 3. Leaving H1B sponsor and staying outside the US. Can EAD AP alone allow re-entry? So I'm working on H1B for the same employers. Valid visa stamp till 27. I140 approved. Approved AP EAD. I have 1 year non-compete with my current employer. As per my non-compete, my employer will pay me monthly base salary till the end of the non-compete. If I leave my job and will my H1B be revoked from 1st March or 1st May after 60 days? Or will my H1B be valid even during my non-compete as my employer will be paying me the salary? So that's something you can discuss with your employer. Tell them not to revoke the H1B because they are paying your salary anyway. So there's no need for them to revoke it. But if they do revoke it, I'm not sure how that impacts because government said we will not start the 60-day grace period as long as you're getting paid until the pay period ends. So your pay period doesn't end for 1 year. That's a very difficult question to answer. I would say the easier thing is to make sure they don't revoke your H1B. Yeah. So all of those questions depend upon how the government views that 1 year of non-compete. Is it required for me to be working to maintain my EAD AP? Well, you have to have that job. Or you have to have a job offer that is same or similar. So that's a little complicated. You want to talk to your lawyers about this. Make sure you get it right. But it's certainly possible to, with a job offer, to be outside on existing valid AP and EAD you don't need. It's the AP you need for travel. Okay. I hope that helps. *5. If you have a follow-up question, press *5. All right. Let's see. Area code 314, Missouri. Missouri, go ahead, please.
Good afternoon, sir.
Good afternoon.
One question. How long can one stay in the U.S. on a pending I-485 and approved EAD if I leave my job or if I'm laid off?
As long as it is pending. So as long as the 485 is pending.
As long as the...
Yep, absolutely. And then what you can do is, if you get a job that you want to take on for a relatively long-term basis, let's say over a year or two, you can file Supplement J to port your job over to that company. And if you happen to leave that company, go to another, you can file Supplement J again. That gives you additional protection. Okay.
Okay, and the job has to be similar.
Same or similar.
What is in the 485?
So similar is as long as it is in your field. So let's say are you a technology person? What do you do?
Finance.
Finance. So let's say you were hired. Let's say you were hired as a financial analyst by a company, but the next company that you go to gives you a job as a finance manager. That's same or similar. Okay.
Okay.
So
And
promotions
the
are
USCIS
okay.
will not send any letter or RFP while I'm unemployed.
Yeah, if they send an RFE, they'll give you 87 days to give them a letter of a job offer letter. So
Okay.
you'll have to get a job offer within 87 days, typically. Okay.
Okay. Thank you.
You're welcome. Good luck. Next question, Sai, number 4. Expedite I-130 review for marriage green card with recent documents. Okay. So F1 student submitted I-130 green card marriage. No. You cannot expedite a green card just because you have a driver's license and social security number, etc. No, that's not possible. There's no such provision in law. Sorry. *5 if you have a follow-up question. Press *5. Okay. Next question. Let's see. This is grace period after layoff. This is question number 7. Grace period after layoff, unused EAD and H1 extension complication. I-485 pending. Okay. My company filed I-485 in 2020. EAD AP valid till 25. Went to India, returned on my AP, filed H1 extension. Okay. Now I got laid off. Will I get a 60-day grace period? I think so. I do believe so. Yes, sir. Can I continue on EAD without any job? Yes, you can. Absolutely. So actually what you are continuing on is your 485. The EAD gives you permission to work, but the permission to stay comes from 485. Okay, so yeah, you can continue to stay. Will there be a problem if I don't have a job for 3 to 6 months? No, I don't think so. That is true. That was the question I was just asked. So unless there is actually a demand for an offer letter, you can continue to be unemployed or even employed otherwise. Can I do a part-time job on EAD while searching for a primary job? Yes, you can. Absolutely. Because you have an EAD. *5. If you have a follow-up question, press *5. Okay, let's go to question number 10. Let me grab some water. Question number 10. I'm on H1B cap exempt, looking to transfer to an H1B cap based. Yeah, let me grab some throat lozenges. I'll be right with you. Just 1 second. Okay, so cap exempt visa wants to transfer to H1B cap based visa. Questions. What ways can I start working for the new employer before October 1st? Only one way, if you do a concurrent H1B. But for that you don't need to be already lottery selected. So let's say I'm on a cap exempt H1B. Okay. And I have a cap H1B available. What the cap H1B people can do is they can file a concurrent H1B. So I'm working both jobs. And when the lottery time comes, they apply for my lottery. If I get selected, they can then file a full-time H1B, what is an H1B amendment or a full-time H1B for me. Okay. And I can quit the old job. Can I work on the receipt of the lottery acceptance? No, that's never allowed. Until the H1B is approved. If you have a concurrent H1B, of course you can continue working. *5. If you have a follow-up question, press *5. Next question is, let's see, this one is number 11. H1B eligibility impact of prior L2 and L1A. I'm on L2. It's been around 5 years. My spouse is on L1A, completing 5 years. If I get picked up in H1B, will I be eligible for 6 years? Yes. L2 does not count towards H1B. L1 does. So your husband will not be able to get 6 years of H1, you will. But if you have an I140, then any time remaining on the H1B, he might be able to he should be able to get ongoing H1B extensions. So once again, to summarize, L2 does not count towards H1B. You have complete 6 years. If he can get his H1B approved before his total time on L1, H1 together is over, he will then be able to get ongoing H1B extensions based upon the I-140. Okay. Press star 5 if you have a follow-up question. Press star 5. Very good. It looks like we might have time for new questions because this is the last question. Can NIW green card holder use AC21? No, you don't use AC21. You use, as long as you are working within the parameters of your NIW application, like similar research, etc., based upon how your NIW was drafted, you can change jobs. That's not a problem. So refer to the discussion I had earlier today about how to draft an NIW. So if your second job is covered by your first NIW, and so is your third and the fourth and the fifth job, no problem. You don't need to port. You're automatically entitled to keep changing jobs. Okay? Star 5, if you have a follow-up question on this, press star 5. All right. We are done with the posted questions. Anybody has any question, press star 5. I'm glad we got some time to talk. So I have only one question up. Let's see. This is from Connecticut, or 2 questions. So I'll go to New Jersey first because they logged in first. New Jersey, which is area code 856. Let's go to 856 first. 856, I can hear you. Please go ahead.
Hello, Rajiv. So here's the deal. I lost my job. I'm on H1B, and I heard before our meeting that I can extend my B2. So I'm planning to apply for B2 like on the 50th day, just so that just to be on safe side.
Sure.
And is it correct that I can extend that after 6 months stay? So overall, I can extend my stay for a year.
Yes.
Okay.
You could do more.
So that was one part of it.
Hold on. Potentially you could do more. It's just that I think beyond 2 B2s, it will be a little unreasonable. It may not be granted. Okay.
Got it. Okay. So the other part is, like earlier, I also asked, I told you that I'm developing an app for artists and whatnot. So my goal is, if in the next 60 days I cannot get a job or whatever, then I will, wrap up everything where I'm at right now and then be on the road and go and connect with people, my potential customers, and pitch them the app and whatnot. So having said that, I'm kind of curious, can I do that in the sense, or does USCIS need me to be at a permanent place or some sort of address to reach out to me or something like that?
NIW does not require a specific job. Okay, you could have a project instead of a job.
Not NIW. Sorry, I meant like I'm on H1B right now, right?
So
after 60 days, I have to surrender my apartment. And I was thinking of just being on the road, just take my car, go to different cities and have potential customers for the app.
Yeah, but that's not...
I don't have the app ready yet.
Yeah, that's not a part of your H1B. So you're not on H1B at that time. Okay? As long as you're not actually...
Correct. I will be on B1, B2.
Yeah, as long as you're not engaged in actually selling something, shaking hands and kissing babies is okay. Okay.
That's interesting. Then, what if I'm selling the app, like with
that would be
on board and whatnot?
That would be a violation of your status. B1, B2 does not allow you to. I'll give you a very good example. This is a real case. Many years ago, it's probably a 40 years old case. So in this case, what happened was
Mm-hmm.
there was a gentleman from Hong Kong who had a B1, B2 visa. Okay, he had a B1, B2 visa, or maybe even a B1 visa. He was a tailor with his shop in Hong Kong. So every 6 months, he would come to USA and he would meet his clients and potential clients, take their measurements, and then go back to Hong Kong, sew their suits or shirts or whatever clothes, and send them back. USCIS said that's illegal, and they tried to visit some harsh consequences on him. The court said this is not illegal because it was court or the Board of Immigration Appeals, one of the two, because he's not working. He is merely getting work to do back in Hong Kong. In your case, you are actually doing the work here, getting the work here, and that's illegal.
I see.
Okay.
Okay. What if I hold because based on the current law, I cannot hold like a majority in any company I will launch, right?
Not yet.
So what if I have like partners who have majority in the company, and
Yeah, they can process.
If I'm still being the
they can process your H1B if you are a minority stockholder. Sure.
Yeah, but I mean, there are tax complications and stuff like that. So I was kind of wondering, taking a step back, can I file a self-petition NIW? And if it's in pending, then can I work on B1, B2 as well? In the sense like
No,
pitch the
absolutely
app to the
not.
investors and the...
Absolutely not. That is, and especially if you're India born, NIW means your work authorization is 13 years away. So you can't work just because you have an NIW. Even approved NIW doesn't give you permission to work. If you were born in a country other than India, this might be a viable option eventually. But right now, no, that's not your option.
If that was the case, I would have a green card.
Yeah, that's true. Okay.
Yeah.
Good luck.
Yeah, thank you.
You're welcome. Okay.
Thanks.
Let me go to area code 475, which is Connecticut. 475, go ahead, please.
Sir, I'm coming back to my question once again. So my H1B grace period got over, but I have filed my I-539 on 50th day. So I have two questions, sir. If I get an employer willing to sponsor my H1, will I need to, is it mandatory that my B2 should be approved before applying for this?
No.
And what?
No, it's not. Hold on. Let me answer that question. It's in our frequently asked questions. You can actually go review it on immigration.com. But it's not mandatory that your B2 must have been approved before you can apply for H1B again. But they will not approve your H1B within USA in most cases unless they have approved the B1, B2. So they'll approve the H1B, but they'll say, go get a visa stamp and come back.
Okay.
That is the reason I said when you apply for H1B, request that your B1, B2 be expedited so that then they can give you the H1B within USA. And they have said that they'll consider that.
Okay.
All right.
And sir, is it considered? Yes, sir. And is it considered an H1B reinstatement?
Don't worry about the nomenclature. It's not a reinstatement. It's basically an H1B, whether you want to call it it's not a transfer. So it's really I don't know what to call it, but it's kind of a transfer and getting back into H1B. No such thing as a reinstatement. Okay.
And if I find an employer maybe on the first week of May, then will this still work, or should I have to follow the general H1B timeline? I mean, application before end of March. Generally, H1B petitions are filed. So if I get an employer maybe towards the first week of May, will it have any problem? Will it get me into any problem or?
No, there is no problem. As long as your B1, B2 was timely filed and you're not subject to any particular timeline. Okay.
Yes, yes.
Good
And,
luck.
sir, like you said,
Ma'am, I think I've
okay.
covered what you need to know. All right. Just read the frequently asked questions. Most of these issues are already covered. I'm just repeating myself. Okay. Good luck.
I have one last question, sir.
Make it really quick because I'm basically just circling around the same questions over and over again. Go ahead.
Yes, sure. So you said it will be better for me to expedite the B2 process. So
You can only expedite it when you file the H1B. You can't expedite it by itself.
Yes. And for that, do I need to file anything extra?
Let your lawyers worry about that. They'll take care of that. That's not your job.
Okay.
All right.
Sure.
Good luck.
Yes. Yeah.
Okay. Last question, guys. Somebody raised their hand. St. Louis, go ahead, please.
Hi, sir. Just one follow-up question. I had asked about staying in the U.S. on a pending I-485 while, if I were unemployed. It is actually under EB2 category, so it could be another 2 or 3 years before the date is current. So if it takes me like more than a year to find a similar job, it is still okay to stay in the U.S. during that time? And do they usually send a letter demanding an offer to show them an offer letter if it is that long of a time, say if it's like 9 to 12 months?
You can stay, and I can't predict when they will send the letter. Usually it's closer to when your dates are getting current.
Okay.
That's how it works. Anything else?
Okay. Thank you so much.
You're welcome. Good luck, guys. Great talking to all of you. I'll see you again next week on LinkedIn. Take care, everyone. Bye-bye.